Hello and welcome to another Thoughts and Opinions video, yet again discussing the topic of former Rooster Teeth star Ryan Haywood. After my last video lambasting Jane Doe for what I believe is being fraudulent, after a bit of thinking and a brief chat with Cutter Historical, someone who has been very vocal during most of my Ryan videos and one that I rather enjoy discussing the topic with, I have decided it would be best to look a bit further into the matter instead of just scratching the surface like a hen scratching for feed. Now, if we want to get the real food, we need to go below the surface to get the worms. Firstly, because it was a matter of contention, is Jane Doe really Jane Doe? Okay, that was a bit redundant. Let's try that again. Is Jane Doe really the one making the accusations and filing the lawsuit? Or is it by chance one or both of her parents? Perhaps it's a close legal guardian, say like a family member or a friend, or another form of family member like say an uncle or an aunt. If this is the case, what is their motive? Is it really for the safety, the well-being and security of a loved one? Or is it again, as I suspect, a false cry trying to utilize the arrogance of today's society, where people will stampede to the cries of a woman claiming to be a victim without thinking about the possibility of it being a lie? Well, let's find out if there really is a chance of this lawsuit being filed by Jane Doe, or maybe a member of her family. In order to do that, let's figure out a few things first. Firstly, we need an age to go off of because if she's no longer a minor, she can then be the one suing Ryan Haywood and Rooster Teeth. However, if she's still a minor, she will not be the one behind any of this. To start, at the time of writing this, of course it's 2022. Ryan and all of his dealings came out in late October of 2020. Jane Doe was 16 at the time she engaged with Ryan on her own accord and willingly met with him in exchange for their agreed upon deal. Now, if this was in early 2020 when these events happened, then there is a chance that she is now 18. However, if this was prior to 2020, she can be 18 or older. But what does this mean for the case though? Well, a quick search tells us that in most states, the age a person is no longer considered a quote-unquote minor is approximately 18 years of age, and at this time, you are now able to file lawsuits and enter into contracts such as, let's say, getting a loan for a shiny new car. The exception here are states like Alabama and Nebraska, where the minor is no longer considered such at age 19. Granted, this isn't entirely true either, as minors can sue people and have done so in the past, but how they do this is with a thing called a litigation friend. I'm going to quote UK practical law here because it honestly makes this very easy to understand. A litigation friend is a person who can fairly and competently conduct proceedings on behalf of a child or a protected party being a person who is, by reason of mental disorder, incapable of managing and or administering his or her own affairs. This litigation friend may be appointed by court order as well. This is definitely something that Jane Doe can use because if she's still a minor, this would be the only method she has available, but a method nonetheless that can pursue a trial for, say, physical or mental trauma. However, if she's above the age of a minor and unable to manage or handle the affairs of a lawsuit herself due to her own self-admitted being special needs, this option would remain available. However, the litigation friend could be made liable for costs should any be mandatory, which for this case with Jane Doe, I think there won't be any, seeing as how she would be the one getting any amount of money if she wins, and none if she fails. However, this is just for the sake of being thorough that I just brought it up. So where do we stand? How old is Jane Doe? Well, if I had to guess, I would make the assumption that she is now 18 years old, maybe possibly 19 or older. Again, Ryan was exposed late 2020, and if Jane Doe had met with Ryan early 2020, where at the time she was confirming her age of being 16 years old, then we can assume that she is at the very youngest 17 on the grounds of her birthday being in the last 2 months of 2020, so November or December. But reasonably, we can assume that her birthday could have been before Ryan's exposure was made. Okay, so it kind of feels like we were doing a lot of talking, but at the same time, we're not moving. So what have we just established? Well, we're establishing that Jane Doe can be reasonably assumed to be 18 years old in which she would no longer be classified as a minor exactly and would be eligible to file a lawsuit on her own behalf without the assistance of a litigation friend. However, due to her own admission of being a special needs person, we can also reasonably assume that regardless of her age, she could still use the assistance of a litigation friend to manage and administer their affairs, which I would say is the most likely option given this person's background. Okay, so we're assuming it's a litigation friend. Who is that, and can it be a friend or a family member? To answer your question, Cutter Historical, it is yes, it can be a friend or family member, but there are ties that come with this. To be a litigation friend, you have to meet a few criteria such as being a parent or a guardian, a family member or a friend, a solicitor, a professional advocate such as an independent mental capacity advocate, a court of protection deputy, or someone who has a lasting or enduring power of attorney. And while that might sound easy, a litigation friend needs to pass a suitability certificate which ensures your interest will not conflict with theirs being the minor or the protected party, and that you can make decisions about the case in a fair and competent way. If there is no one to act as the litigation friend, then the official solicitor will act as such if the criteria is met, such as no one being suitable to act as the litigation friend, there is money available to pay the solicitor's cost, an example being legal aid, or if the person's doctor, say, like a psychiatrist, can confirm that they lack the capacity to manage the case unless they are a child, of course. So with all of that, what do we think is the best option here? Well, I would opt to say that for Jane Doe, the best bet she would have is to use an official litigator because a family member won't likely be able to make the choices in the best interest of the minor or protected party, especially considering this case. I mean, we gotta remember what Ryan is potentially doing here. However, it's not out of the question that it could still be a family member or some form of legal guardian. So if I had to take a complete and honest guess as to what I think is going on, Jane Doe's best option is to use a litigation friend and hope that her mental disability is enough to warrant one. That would look good for her in the court, and it would have someone who is in a better mental condition making the decision. I mean, Jane Doe isn't exactly on a streak of making good decisions now, is she? And while I still believe that Jane Doe is lying for attention and going for a cash grab, we still need to treat this as a serious matter, as there is a chance that Jane Doe isn't lying. So with all of that out of the way, what more is there to look into? Well, something I looked into but chose to leave out in my other video was that despite there being absolutely no proof against Rooster Teeth on the count of negligence, it does appear that even they, Rooster Teeth, agree that there was no substantial evidence, if any at all, to prove Jane Doe's case. And just for the sake of making this easy, I will display an image with the official response to the court and using an arrow right here to point at the section being discussed and breaking it down into a literal, easy to understand method. Special thanks to Reddit user Sekana Tudabatsu. I'm gonna hope I'm pronouncing that right.
The defendant generally denies all of the allegations contained in the plaintiff's petition, and since they are allegations of fact, the plaintiff should be required to prove them by preponderance of the evidence in accordance with the laws of the state of Texas.
What this basically means is Rooster Teeth is saying that they didn't do anything wrong.
The defendant maintains that plaintiff's claims are barred, in whole or in part, by the applicable statutes of limitation.
What Rooster Teeth is saying here is that they can't be sued for this because it happened a long time ago and the deadline for something to be done about it has passed.
The defendant maintains that plaintiff's claims are barred, in whole or in part, by the doctrine of lashes because plaintiff unreasonably delayed in asserting her claims.
And what this means is, even if the deadline didn't pass, the fact that they waited so long to report it shows that they have no damages to show for it. Basically saying, well, she can't be mentally traumatized because she took so long to report it.
The defendant maintains that it is free of liability. However, in the unlikely event liability is imposed, it is entitled to contribution pursuant to Chapter 33 of the Texas Civil Practice and Remedies Code from each party to the extent that any acts or omissions of that party in violation of the applicable legal standard proximately caused or contributed to cause any damages for which it may be liable in this matter. Defendant reserves the right to submit issues to the jury of the alleged negligence of other parties, settling defendants and/or responsible third parties.
And what this basically means is they're saying they didn't do anything wrong. But if she is awarded for damages, they are basically stating a chapter in the Texas Civil Practice and Remedies Code, which puts an upper limit of how much they can be sued for, which I believe with the Texas Civil Law or Civil Practice and Remedies Code, it's like 50%. So she would not get the $1 million as she's asking for. She'd get half of that, I guess, at best.
To the extent that other parties, any settling persons, and/or responsible third parties are found to be negligent, and their negligence was a proximate cause of contributing cause of the damages in question, defendant hereby invokes the doctrine of comparative fault under applicable law and requests a determination of percentage of responsibility among the parties, settling persons, and/or responsible third parties. Defendant pleads any and all provisions of Chapters 32 and 33 of the Texas Civil Practice and Remedies Code applicable to this action.
And what this means is that because there are multiple people involved and they're saying Ryan's the one at fault, if the courts find that Rooster Teeth and Ryan are both at fault, the damages awarded to Jane Doe get split up by the parties and each pays a portion. Basically saying we split the bill 50-50.
If plaintiff has settled with any defendant or other settling person and has awarded any amount of damages in this cause, the award must be reduced by the dollar amount of such settlement in accordance with Texas Civil Practice and Remedies, Section 33.12.
And what this is meaning is go back to 2.3, they're saying that if they reach the upper limit and they're only partially responsible, then they only have to pay a portion of that limit.
Defendant pleads the affirmative defense of sole proximate cause in that the actions or inaction of one or more named co-defendants, third-party defendants, cross-defendant, or responsible third parties was the sole proximate cause of the accident and issue and plaintiff damages.
Basically, someone else is at fault, we didn't do jack.
Defendant asserts that plaintiff's damages are the result of the conduct of another party over whom which defendant exercises no control or right of control.
RT is basically saying that their association with Ryan was only a coincidence and that they had no control over his actions and that he alone should be responsible for the damages he caused.
Defendant asserts that plaintiff's alleged damages were the result of independent, intervening, and/or superseding factors, occurrences, or conditions that were not caused or contributed to by defendant and for which it is not liable.
Basically, again, they're saying it's Ryan's fault, he's responsible, he should be the one paying for damages.
Any alleged negligent or culpable conduct of defendant, none being admitted, was so insubstantial and to be insufficient to be approximate, producing, or substantial contributing cause of plaintiff's alleged damages.
Basically, they're saying the plaintiff, Jane Doe, has not provided any substantial evidence that RT is at fault. And honestly, they're right. She has not provided anything, so they're just calling it out like I said.
Defendant demands a trial by jury and shall tender the required jury fee.
I don't really think I have to explain this one, but for anyone that doesn't know, Rooster Teeth is saying they want a jury trial. They want to go to court, they want to present their side of it, they want Jane Doe to present her side of it, they want Ryan to present his side of it. They want to basically wash their hands of it and show that they did nothing wrong, and that's it. That's basically what they're saying. They want a jury and that they will pay for whatever fees they need to pay to get a jury. So what does all of this mean really? Well, essentially speaking, Rooster Teeth is saying that Jane Doe has nothing to show for her claims, and that if she is going to be making these claims, which if false can be seen as libel, slander, defamation, whatever you want to call it, they want to see the evidence proved in the court of law with a jury, and if such evidence is true and they are able to provide any, they are making a play on every front, basically saying even if it is true, you waited too long to come out about this, you refused to provide us evidence in advance, and of course, Ryan did it, we didn't tell him to do it, so why are you suing us? And if you win, we want to pay as little as possible as a result. And I say that's really good on Rooster Teeth, because already I have made it very clear that while a lot of people in the company thought it was weird that Ryan stayed behind on trips, that alone is not enough to prove they knew. It is not evidence to say they were already well aware of what he had done. It's very well likely that anyone that makes the same claim Ryan did, it would be true and honest, albeit still suspicious, though being sus isn't exactly illegal. As for Ryan, he only responded with answer, which is just a legal way to say they are here, they have been served their papers, and they are ready to go forward with the trial. He isn't confirming nor denying, he's just saying ready to move forward. Alright, that's two things out of the way. Let's see if we can't hit one more. Is this a case of opportunity? This is a tough call because I'm inclined to say yes, but we don't know the full story. To take from what Cutter Historical thinks, this could be another example of someone trying to settle for some arbitrary amount because they know if they go to an actual trial, they will lose. And while I can see this being the case, I have only one question to ask. Why is Jane Doe afraid of losing? I mean, if Ryan is guilty and Jane Doe has the evidence to prove her case, why would she be worried about losing the trial? I seriously doubt that the court will rule against her, though I do believe even they would laugh at the stupid amount she's aiming for. However, they probably would award her some amount of money. Say at the low end, $25,000, up to the highest end, $80,000 at most. Maybe more, I don't know, I'm not an expert, but I would say $80,000 is the most someone could probably get if you were going to lose a case but still get rewarded something. That's probably the most you could get. Again, I don't know if this is just a settlement scam or one they know won't work in court, so they're just hoping for a Hail Mary to get a legitimate settlement deal and just move on. But one thing I know for certain is that Jane Doe has done nothing to prove her case. All we have is her own words and nothing else. The other women had the decency to at least publish their proof so that way it could be analyzed by professionals and validated by everyone online. Here with Jane Doe, we have nothing but a story, and that makes very little sense on that. If and when the court date is set, we will find out what it is that she has to offer. But if they settle, it only leaves me further suspicious that there really was nothing but smoke and mirrors. And with that, I think we're going to call it here, guys. Any longer and I might as well just do a live stream and just ramble about it, which doesn't really seem to be fun for anyone else, but it would be fun for me. I want to say thank you to anyone who made it here in the end, and to Cutter Historical, as always my guy, I look forward to your insight and comments. I'm looking forward to what you have to say about this, and maybe in the future, maybe if I can ever learn to do something more complicated, I will just live talk with you over Skype or Discord or, something, whatever the people use nowadays, so we can just hash things out properly live and whatnot. I suspect that would be a load of fun, and of course, I wish you well, my guy. You are awesome, love to talk with you, and for the rest of you people, I hope you enjoyed the video, and I'll be seeing you all in the next one.